I was on the front line of this issue, overseeing dozens of executions. I know a little bit about this process. So when the Constitution Project called me and asked if I was interested in forming this study commission, and they told me that they were more interested in studying the entire capital punishment process, rather than all the folks at that time, about a year and a half ago, was on executions. But they wanted to study the entire process, from the initial interrogation and arrest clear through the execution. And I was intrigued. And so as I thought about it and called them back, I said, I will do it, but I insist on three things. I insist, number one, that this commission be truly bipartisan. Number two, I insist that all of our recommendations be by a consensus of the commission. That means that any one commissioner could have veto power over any recommendation. And believe me, that veto power was used during our process. I also insisted that there be no agenda, that we start with a clean slate and we end up wherever the facts and data take us. They agreed, and so we formed this commission. I've had the pleasure during this year and a half of working with two brilliant co-chairs. First, State Regent Andy Lester, who is right here beside me. And each of you, as I call your name, I'm going to introduce the entire commission. You guys wave or something so everybody knows who you are. Andy Lester is a partner at Spencer Fane Law Firm. He is a former U.S. Magistrate Judge for the Western District of Oklahoma, and he had the great honor of serving on Ronald Reagan's transition team. Unfortunately, my other co-chair, Judge Rita Strubar, is traveling and couldn't be with us today. Judge Strubar is a former longtime judge on the Oklahoma Court of Criminal Appeals and was the first woman appointed to serve on that court. She also is a former assistant district attorney in Canadian County. I'd also like to introduce our incredible team of commissioners. Robert Alexander. Wait, there you go. Robert is the founder of the law office of Robert Alexander Jr. He is a Harvard Law graduate, and his law firm represents exclusively Fortune 200 companies around the country. Howard Barnett. Howard, as most of you know, I think, is the president of OSU Tulsa. You might also remember that he served as the chief of staff for Governor Frank Keating and a stint as the Secretary of Commerce. Dean Andy Coates. Dean Andy Coates is the Dean Emeritus of the OU College of Law, the longtime partner at Crow and Dunlevy, Oklahoma Hall of Fame inductee, and of course is a former district attorney from Oklahoma County and former mayor of Oklahoma City. Dean Valerie Couch. She is the dean of Oklahoma City University Law School and the first woman ever to serve in that capacity. She also served 13 years as a federal magistrate judge for the Western District of Oklahoma. Maria Kohler is an assistant professor at the OU College of Law. She's kind of our resident expert on the commission because she teaches this subject at OU Law. She teaches criminal law, criminal procedure, and capital punishment. She also served 13 years as a law clerk for the Oklahoma Court of Criminal Appeals. Christy Shepard. Christy is a licensed professional counselor and a well-known victims' rights advocate. She has spoken throughout the country on behalf of victims. The Honorable Chris Steele. Chris, of course, is the former Speaker of the House of Representatives and currently serves as the Executive Director of the Education and Employment Ministry. He's also an ordained minister and is chair of Oklahomans for Criminal Justice Reform. Finally, but certainly not least, Gina Timberman is the founder of the Look-See Group. She is also the former director of the Native American Cultural and Educational Authority. She's a graduate of OU Law and advocate for all things Native American, especially for cultural projects in Indian country. Thank you to all of you for your service and volunteering your time for nearly a year and a half. I must say that I've had a wonderful opportunity during my life to work with really great people. But I've never worked with a better group of people than these people standing here beside me today. Thank you, all of you, for what you've given me during this last year and a half. Now, last spring, many Oklahomans had become concerned about the integrity and the fairness of Oklahoma's death penalty process after the system and its execution protocols came under increased scrutiny. On October 2nd, 2015, the Court of Criminal Appeals, at the request of the Attorney General, issued an indefinite hold on all scheduled executions in Oklahoma, while a grand jury investigated the execution process. We came together as concerned Oklahomans, as a bipartisan group, to independently study the entire capital punishment system, from arrest to execution. As I said, this has never been done before in Oklahoma. The commission includes 5 women and 6 men from both urban and rural communities, Republicans and Democrats, prosecutors and defense attorneys, individuals who have served in each of the 3 branches of government, law school professors and law school deans, and victims advocates and advocates for Native Americans. It is a well-balanced and representative group. Now I'd like to call on my wonderful co-chair, Regent Andy Lester, to address our fact-based, research-driven approach to this monumental task.
Well, thank you, Governor Henry. It's been a pleasure to work with you, with Judge Strubar, and all the commissioners during this past year. In our initial meeting, we all agreed that we wanted to hear from all parties who are directly involved in the capital punishment system. In the course of our 10 meetings, and when I say 10 meetings, those were 10 full-day meetings, we heard from a number of stakeholders, including law enforcement, prosecutors, defense attorneys, judges, families of murder victims, and families of those wrongfully convicted. In addition to those in-person meetings, those 10 in-person meetings, we spent countless hours on conference calls and communicating via email to discuss our findings and to develop the 46 detailed recommendations in our 300 or so page report. We gathered data from state and local government agencies, including the Governor's Office, the Oklahoma Supreme Court, the Oklahoma Court of Criminal Appeals, the Oklahoma Attorney General, the Oklahoma Department of Corrections, the Oklahoma District Attorney's Council, several district attorneys, several district court clerks, sheriffs, police departments, the Oklahoma Indigent Defense System, and many, many others. Also, we reviewed scholarly articles, and we commissioned further research so that we could better understand and interpret the data and for comparative analysis. Several individuals and entities assisted the Commission with important data collection and contextual research. And this was done to analyze rates of error, costs, disproportionate application of the death penalty, all of which appears in the appendix to the report. Many of these people provided assistance on a pro bono basis, and they two are listed in the report. I want to thank the Constitution Project for providing staff and researchers to the Commission. The Constitution Project is a bipartisan nonprofit organization that fosters consensus-based solutions to the most difficult constitutional challenges of our time. And although I wasn't in part of the conversation that Governor Henry had with the Constitution Project, if you were to look at the Constitution Project's website, you would see that that bipartisan portion of it absolutely fits with what the Constitution Project does and who the Constitution Project is. I also want to thank several institutions who made their facilities available for Commission meetings. Oklahoma City University Law School, the University of Oklahoma College of Law, Langston University, the Oklahoma State Regents for Higher Education, and the law firms of Spencer Fane and Crowe and Dunleavy. As you can see, the Commission's work was very inclusive. It involved the input and support of many Oklahomans, and you will see this reflected in the report. Let me turn the microphone back over to Governor Henry to announce the Commission's report.
Thank you, Andy. The Commission, as you heard, has written a nearly 300-page report with over 40 recommendations, 46 I believe to be exact, to address systemic problems in key areas such as forensics, innocence protection, the execution process, and the roles of the prosecution, the defense counsel, the jury, and the judiciary. Our primary recommendation, based on our in-depth study and work, is that the state of Oklahoma should extend the current moratorium on executions until significant reforms are accomplished. The Commission did not come to this decision lightly, but this recommendation was unanimous. We were all disturbed by the volume and seriousness of the flaws in Oklahoma's capital punishment system. This year-long investigation led members to question whether the death penalty can be administered in a way that ensures no innocent person is put to death. Commission members agree that, at a minimum, those who are sentenced to death should receive this sentence only after a fair and impartial process that ensures that they deserve the ultimate penalty of death. Our hope is for this report to foster an informed discussion among all Oklahomans about whether the death penalty can be implemented in a way that eliminates the unacceptable risk of executing the innocent, as well as the unacceptable risk of inconsistent, discriminatory, and inhumane application of the death penalty. We all cherish Oklahoma values and aspirations of innocence protection, procedural fairness, and justice. We encourage the Oklahoma legislature, the executive branch, and the judiciary to take actions to address the systemic flaws in the death penalty system. And we will be meeting with leaders in all three branches. Commissioners stand ready to work with Oklahoma stakeholders to implement our recommendations. Before we open the floor for questions, I'd like to read a statement from my co-chair, Judge Rita Strubar, and then one of our commissioners, Christy Shepard, will discuss how the recommendations of this report can actually impact the lives of Oklahomans. Here's the statement that Judge Strubar sent. I wish I could be there with you today. For the past year, it has been an honor to serve as co-chair of the Oklahoma Death Penalty Review Commission. We came together from all walks of life shortly after the state of Oklahoma imposed a moratorium on the execution of condemned inmates. I am proud that the commission included Republicans, Democrats, independents, prosecutors, and defense attorneys who represent all viewpoints of the death penalty. With endless hours of discussion based on solid and comprehensive research, I am most proud that all the commissioners unanimously agreed on the main recommendation that the current moratorium on executions should be extended until significant reforms are made. It is very important for Oklahoma to get this issue right. Signed, Judge Rita Strubar. Christie?
My family has known the elation and satisfaction of the ultimate punishment of the death penalty being handed down after my cousin Debbie Carter was brutally murdered in Ada in 1982. We felt that the justice that was sought in Debbie's murder was fair and deserved. The only truth we had surrounding the last few hours of Debbie's life was unveiled and played out on the stage of our local courthouse in separate trials for Ron Williamson and Dennis Fritz. Then, more than 16 years after Debbie had last been seen alive, DNA testing proved them to be innocent. We watched those two men who we believed were responsible for her death simply walk away, taking any truth that we had with them. After another 2 years, the third trial was underway with the man who matched the DNA. He was convicted, and again my family felt that justice was served and the death penalty was handed down. But after 2 more years had passed, the third conviction was then overturned, and we would be heading back to the courthouse. 22 years had passed, and the fourth trial was on the horizon. We had lost all faith in the criminal justice system, in addition to the agonizing guilt that 2 innocent men had suffered. That fourth trial ended with life without parole, which seemed somewhat of a relief, that maybe now the looming anxiety of Debbie's justice being ripped away was over. For my aunt, Debbie's mother, Aunt Peppy, the death penalty had become a false promise. Over the last 10 years, I have met numerous individuals who have been wrongfully convicted and walked away from death row, many of who I call friends. I have chosen to learn more about the criminal justice system and how it plays out in real life and how the death penalty fits into that. This commission has been an honor to serve on and has helped add a wealth of further knowledge specific to our death penalty process here in Oklahoma. While I struggle with what punishment would seem adequate for the suffering of Debbie and her family, nothing will ever make my Aunt Peppy whole again. But the truth would have been a good place to start. DNA freed Ron and Dennis, but lots of issues helped keep them wrongfully convicted. This commission's in-depth study will show that truth, fairness, and justice can be lost due to systematic problems in our death penalty system. When you have a loved one who is brutally raped and murdered, there is no such thing as closure. But to avoid the added trauma and suffering my family endured trial after trial, along with innocent men going to death row and to prison, the state must take a serious look at what is wrong with its death penalty and implement real reforms. But these issues matter to real Oklahomans like my family. Thank you.
Can you please say and spell your name really quick before you?
Christy Shepherd, Christy Sheppard.
Thank you, Christie, for that moving testimonial. You know, for me, I can kind of sum it up this way. Some members of this commission would advocate for abolition of the death penalty. Other members of this commission are staunch defenders of the death penalty. But we all agree that if we're going to have a death penalty, it must be done right to ensure that no innocent person is ever put to death. We'll take questions now. Pat?
My question is, did you, in your nation, leave the moratorium in place? That was my first question. And the second is, given the situation with the Glossop conviction, which now the legal remedies have, at least on paper, been exhausted, but the indications of his innocence get clearer every day and are certainly persuasive to me. What, in the state do as a legal matter to address the Glossip issue, and did you find it any place to address it?
Sure. Worked with a lot of wonderful colleagues. Am I surprised we got a unanimous agreement? Not, honestly, not really. And especially after the year that we studied. And that's, to be sure, there were significant differences of opinion. And they were expressed clearly, and as one would hope. But on the moratorium, that was, it was unanimous. It wasn't all that difficult to come to that conclusion. That seemed to be absolutely clear to all of us. Look, I'm not sure that it would be appropriate for us to comment on the specific case. There is the justice system. The justice system works in many ways, works well in many ways, and one hopes that before any executions take place, that, well, I hope, I should say, that before any executions take place, there will be significant reforms. I mean, there are cases are starting. We're at those beginning stages in some matters. We're at the end stages in other matters. I hope that our government leaders will take appropriate steps to reform the system to make sure that we don't have future problems with innocent people being executed.
Did you look at the DOC's procedure and using midazolam or anything like that, or did you strictly look at, up until you get DOC custody?
Yeah, no, we did look at the procedure of the Department of Corrections. We studied the grand jury investigation report, and we make a number of recommendations that specifically impact the execution process as well as DOC protocols. We agreed with the grand jury's recommendations with respect to the protocol. We also recommended, and I mean, we looked at various forms of execution throughout the United States, and we believe, based upon our comprehensive review, that the better protocol currently, and best practices evolve over time, but the current best protocol is a one-drug barbiturate protocol rather than the three-drug cocktail that we have here in Oklahoma.
Governor, of all the recommendations, what did you discover that you find most troubling about the way the death penalty is administered in Oklahoma? And I guess you answer that.
That's a tough question to answer. As Andy said, as we studied this process, it became so clear to us that the death penalty process has serious flaws, that it wasn't difficult for us to reach the conclusion that the moratorium ought to be extended until significant reforms are made. But I think the obvious answer to me is lack of resources, lack of funding. If you look at the various defense council organizations, whether it's OIDS or Oklahoma County or Tulsa County Public Defenders, I mean, they are just overwhelmed with felony cases. They don't have enough attorneys. They don't have the funding that they need, especially in death penalty cases, to hire investigators, to hire experts. And I think for a lot of us, and I think this frankly is a conservative viewpoint, you have to decide whether you want to pay to do it right. And either you do or you don't. And right now, we are not providing the financial resources, among other things in Oklahoma, to do it right.
Particularly at the trial court level.
And especially at the trial court level. And what happens many times, and I think if you talk to most prosecutors and they're honest with you, they will tell you that they want well-prepared, well-staffed, well-resourced defense counsel because they want to get it right the first time. They don't want to go up on either direct appeal or some other level of appeal and get reversed or get it kicked back because of some issue like ineffective assistance of counsel. I don't know how many of you saw the 60 Minutes report this weekend, Sunday, but I would recommend that you watch that because they detailed this exact same problem in another state, and they've had just horrific results. And you know what happens is you may get innocent people on death row, and we know we have in Oklahoma because since we reinstated the death penalty in Oklahoma in 1977, we've had 10 people exonerated from death row because they were later found innocent.
Do you believe that Oklahoma may have put an innocent person to death?
There's no way I can know that. It would be sheer speculation, but based on my review of the death penalty process over this last year and a half, I believe that it's very likely that at some point Oklahoma has executed an innocent person. I don't know that to be true, and I don't think we'll ever know, but I believe it to be likely.
If I could add a couple of things to that. I don't know the answer to that question, but what I do know is I certainly don't want it to happen going forward. And we need to do everything we can to make sure it doesn't happen going forward. On the point about resources, we heard that repeatedly from everybody, especially from the prosecutors. I had one prosecutor who said specifically, if you do nothing else, make sure that you get the resources for proper defense counsel and for proper education and for the experts that are necessary to try cases. This is important to everybody. It's not just, this isn't one-sided. This was coming from the prosecutors.
We'll all know soon, but does the report have any provisions for making more robust the possibility of post-conviction appeals, all of things like the Glossop case, although there's others? Can you respond to that?
You want to take that one? Bring in our resident criminal law expert.
The report did look at that. Innocence protection was a big focus of the report, and generally, the goal of a number of recommendations in that realm were that we open up the process, that we don't have false deadlines, that when the science changes, we're asking the Court of Criminal Appeals to allow discovery, to allow relooking. And we also specifically are recommending that the Oklahoma direct appeal process and the post-conviction process be separate. That sounds very much like a lot of lawyer talk, but basically, we have a rather unusual system right now where the direct appeal overlaps with the further appeal. And basically, our recommendation is to do one at a time, look at record-based claims, things like that came up at trial, look at trial transcripts, look at testimony, and then give more later time, significant time for the kinds of investigation that comes up in capital cases, looking at, person's life history, potential mental retardation, intellectual disability issues, abuse issues, brain development, brain injury issues, that kind of thing. But yeah, a big theme overall of the court report is to sort of throughout the process, from initial contact through execution, to have every opportunity to avoid the execution of an innocent person. That includes the appellate process.
So are you suggesting that everybody on death row get a new trial, better resources?
Certainly not. Certainly not. And I mean, that wouldn't make any sense. All of our recommendations, I think, are reasonable and are based on recognition that every case is different. But particularly in terms of going forward, that we want to set up a system that doesn't shut down claims, it doesn't shut down research and reconsidering when it comes to the ultimate penalty. Because in the end, perfection is probably not attainable in this life, but the difference with the death penalty is the finality. And once an execution is imposed, it's over. And there's no sorries, and there's no, we made a mistake, we're so sorry. And so one of our biggest goals is to make sure that the process, if it comes down to the implementation of an execution, after all fairness, that we can feel sort of with the moral certainty that it's been fair and that we won't execute an innocent person.
States have been unable to obtain the one drug, the fast-acting barbiturate that the state would prefer to use. And even midazolam is getting more difficult to obtain. Oklahoma has recommended or has approved nitrogen gas as an alternative. Did the panel consider that? And what are your thoughts about looking at an alternative method of execution?
Who wants that one? Well, I mean, sure, we looked at the Oklahoma laws surrounding execution and what's allowed. I think I don't think we would recommend the alternative because of just the unknown issues and problems, the litigation that would likely ensue, and it's not really proven that it's a humane form of execution. I mean, Oklahoma, yet again, is first in the country to come up with this form of execution. We were also the first in the country to come up with lethal injection, which I think was probably better than the electric chair in terms of all of the constitutional requisites that must be met. But again, our recommendation is that it appears that the best practices are to use a one-drug protocol. There's less room for error. You're not going to have nearly as much problem administering one drug as you potentially do with 3 drugs.
If I could just add, look, no medical experts here and on our panel. We don't know truthfully, what the best method would be. We've read an awful lot, and it does appear right now that the best practice would be simply the one drug. But that could change. This science is changing all the time, and our recommendation, among other things, is that we keep up with the science, that we keep up with what the best practice is.
Sure.
Just one thing, although we didn't have a specific recommendation of a particular drug, we all agreed unanimously what the criteria would be. The criteria should be the most humane and effective, according to the science available. That would be the criteria. Whatever the choice is, and it will ultimately be made by political branches in response to the people, but the criteria is the most humane and effective method available.
I asked, did you have an opportunity to visit death row or take into account did you interview anyone on death row? If not, why?
No, we did not. We did not. We did interview family members of death row inmates, but we did not go to death row and interview inmates. That's a difficult process, especially for a group this big. We probably could have gotten that done with a couple of individuals. But look, our work and our research and our study was vast and comprehensive. We visited with all of the stakeholders in the system. And again, the more we looked at it, the more disturbed we became. And we felt like it was necessary to extend the moratorium and work on reforms. And if you look at the 46 recommendations that we've outlined in our report, to me, there are a couple of common themes or threads that run through those recommendations. One is lack of resources. We need more training at every level. We need capital punishment training for defense counsel, for prosecutors, for judges. We need training for law enforcement on the best methods of interrogation or eyewitness identification, which can be inherently unreliable but very, very powerful in a court of law before a jury. So, you know, training has a lot to do with it, and that costs money, and that requires resources. The other common thread was innocence protection. We want to, again, make sure that no innocent person is ever convicted and sentenced to death row and executed. And so many of our recommendations relate to innocence protection in various ways.
When the
We'll take
use
one
of-
more question, and then we'll wrap it up.
When the use of midazoline was litigated here in federal court in Oklahoma, experts testified that it had a plateau effect, and I was curious if that's what gave the commission the most pause about using a three-drug mixture.
Well, I mean, that was the drug that was used in the so-called botched execution. I think that certainly was a factor. I mean, we studied all the research, and it was our determination unanimously that the one-drug protocol was the best practice. And there may have been different reasons for different commissioners, but to me, that certainly was a troubling issue.
Can I get one question? You just,
Okay, one more, and this will be the last one, then, oh, go ahead, Mr.
Yeah.
Alexander.
if I may, let me respond to the reporter's question about whether there's a likelihood or whether one might hold an opinion, whether there's, no one knows that or can know that for a fact. But I present a context in which we could all ask that question and answer for ourselves. We stand here in 2017, 110 years since statehood. Another 17 years if you count territorial days. And 41 years since the United States Supreme Court lifted a moratorium on executions because, in the words of the Supreme Court, it was freakishly imposed, arbitrarily. And our report has found, 41 years later, systemic flaws in our death penalty system. Now, whenever there's a systemic flaw within a system, any injustices that system could cause would fall most heavily on the people with the fewest resources to navigate that system. Black, white, red. I did research and I couldn't find a situation, speaking for myself, where a wealthy person was not only not guilty, but even charged with the capital. But the death penalty was sought. And so now, in a context in which over 110 years, and we still see systemic flaws, then if one asks the question, and which we found in the past 10 years, recent years, 10 people exonerated, factually innocent, to take away the legalese, people who didn't do it, who didn't do what they were charged with doing. If you extrapolate that over 110 years, speaking personally, I don't have any problem in assuming, no one knows, but in assuming that indeed someone has been wrongfully executed. Now, as the governor said, many people would go further or go not as far in our recommendations, but we all agreed unanimously on the proposition. And we think that with the information that this report will make available to good citizens of Oklahoma, all would agree that an innocent person should not be put at risk of his life in a trial. We found systemic problems in our death system as it exists right now that could possibly lead to that result. And that's why I voted for the recommendations which could better the system. And then as to your question whether we visited death row, we were studying the system, not individual cases. And then 2 points that all might find shocking, if you find other things shocking as we did when we read the report. What shocked me personally when I read the report, as we prepared the report and as we studied for over a year and a half, was the fact that 2 of the methods of conviction, or the tools used during conviction that would intuitively seem to be the most reliable, we found to be those unreliable. That's eyewitness identification and forensics. Eyewitness identification, we would think it's absolute, but the facts and the studies show that it's not, and history shows that it's not. And our report also includes recommendations that the forensic procedures be fortified, and also the qualifications of the experts, but most importantly, resources to a person defending themselves.
We'll take the last question from Phil, and then we'll wrap up, and we have full copies of reports for everyone.
The only question I had, Governor Henry, is do you think there's the political will in this building to approve any of the recommendations in the report?
I think so. I think so, and I think they're demonstrating that this year with some of the criminal justice reform legislation that they're considering. So I think the political will is there, and it ought to be. I mean, again, when you boil it all down, what we're saying is, if you're going to have a death penalty, you have to do it right. I don't think anybody would oppose that position. It's not being done right. There are far too few resources and other systemic problems. And so, you know, this state has, I think, has a decision to make. And that decision is, do we want to pay for the death penalty? Do we want to get it right? Do we want to put the resources into it? Do we want to reform the laws to make sure that we never execute an innocent person? And if we do, then fine. Let's do it right. But if we're not willing to pay for it, if we're not really willing to do it right, we shouldn't have it. And that's essentially, you know, I want to be clear. In our report, we are not attacking the legislature or the executive branch or the judiciary or prosecutors or defense attorneys. We're not attacking any of the stakeholders. We're saying, look, you guys do a great job with the limited resources that you have, but you need more resources, you need better training, you need all kinds of things to make sure this process is truly fair and impartial, and someone who gets the death penalty actually deserves the ultimate penalty of death. That's what we're saying. And in fact, our report, I think, is not contrary to the vote of the people on State Question 776. I think it's complementary to that. I mean, one would argue, well, the people of Oklahoma have spoken and they want the death penalty. Fine, we didn't say abolish the death penalty in our report. We're looking at the process. And we said, if you want to do this, it must be done right. And here are ways that we think it can be corrected. You know, we don't know it all, and there are other ways, and you know, not every single one of our recommendations must be adopted, but our recommendations would go a long way from where we are today in ensuring that no innocent person is ever put to death.
Thank you.